Thank you very much, Rick. I'd like to thank you for inviting me back to Ringling College, and I'd like to thank Ringling College for organizing this symposium. I think it's very timely, and I know that I've already learned a lot through conversations with other speakers and also through the presentations. And of course, I'd like to thank them for their presentations as well, because they really stimulated a lot of thinking on my part. So what are we going to do today? All right. Well, we'll try to make it as painless as possible. Okay. Rick has asked me to give a update on some of the legal issues that are involved with artificial intelligence and with the law. So to begin with, just a couple of disclaimers. Okay. My presentation, unfortunately, isn't legal advice. So circumstances and applicable law vary widely. So if you have a specific question about a specific set of circumstances, well, at least try to hide it behind a hypothetical so I can address it. Otherwise, I'll probably send you to your own attorney. Okay. All right. The views I will be expressing are my own. Okay, they are not necessarily the views of my clients or the law schools where I lecture. So, I will admit, that I have certain perspectives, and I'll disclose what those are, and you can take them for what they're worth. One is that I spent a good half dozen years working in the software industry, and dealing with copyright and piracy issues there, right? Also, in the intervening years, I've had a number of clients who are artists, songwriters, and journalists, and other people who are producing literary and artistic works. So somewhere in that mix, I've had exposure to a number of different client problems. And I hope that'll give me some perspective, a little bit of analytical distance on this issue, and I hope it'll help to make the presentation more useful for you. All right, so here's the agenda for today. I'd like to update the status of the copyright infringement lawsuits that have been filed throughout the United States in federal district courts, and sort of explain where they stand now. Most of those suits were brought by artists, like yourselves, authors, against developers of AI models, like Leon, or providers of AI systems, like OpenAI and ChatGPT. Two, I'd like to give you an update on recent developments in the US government agencies and legislation in the US Congress concerning artificial intelligence and legal regulation in what I'll call the soft IP field: copyrights, trademarks, unfair competition. I'd like to identify key AI provisions of collective bargaining agreements involving work for hire artists, like animators, scenic designers, art directors who are working in the entertainment industry. Outside of the topics today are going to be performers' rights. There just isn't time to really deal with that this afternoon, but it is a very important area, and we're already seeing sort of federal activity to provide some sort of minimum level of rights for performers to prevent people from using digital replicas that imitate their voice and their appearance. So if you're interested in that topic, please stop by after my presentation. I'd be happy to discuss it with you. All right, so let's begin with the promise, and we've heard a lot about that this morning, and there is a great deal of promise. The promise of using AI systems to expand artistic vision and accomplishment. We've seen, great example from Amelia's film, this morning, and we've heard about a lot of other applications of AI in the creative process. And we're going to see workshops tomorrow about that. And I'm looking forward to that. Also, we have some sort of forecasting of what the environment will be, at least for artists who are going to be working as employees in the entertainment industry. And I understand a number of your graduates go on to video games, motion pictures, television production. So a recent survey that was commissioned by the Animation Guild and other trade groups took a look at the opinions of entertainment industry executives in several sectors, film and TV, theatrical performances, and video games. And what they found was that there is a great deal of enthusiasm as well as concrete plans to significantly deploy AI systems in their pre-production, production, and post-production processes by 2026. So these is really very promising. Okay? Now, being from Washington, I want to also tell you about this, because a phenomenon that we often experience there, which is a bit like humid weather in the summer, is FUD, fear, uncertainty, and doubt, right? People really don't know how integrating generative AI into creative processes is going to work out as a matter of commerce. What does it mean in terms of securing property rights in the artifacts that are created through the process? Where do we draw the line between how much human authorship is needed to obtain a copyright in an image or text, and how much AI involvement is too much, where the machine is leading rather than assisting? So there's uncertainty about the assets being created, to make it plainly commercial, right? We also don't have much transparency into what happens inside the AI modeling process and then the use of the applications to create output. We're going to get some more transparency because one of the key features of the lawsuits that have been ongoing for a year and a half now is a process called discovery, where both sides have to sort of show their cards and why they think or don't think that there's an issue here. And then third, and this is something that Kurt was addressing this morning, we really don't have a reliable way to assess the origin and authenticity of the images, the text, and the sounds that are created using AI models and AI systems, right? And I think John was referring to some of that too in his presentations on the computer science side of AI this morning. So we don't have those things. That doesn't mean we won't ever have them. In fact, I think we're going to have more information and more guidance in the next couple of years. But this fear, uncertainty, and doubt causes worry among some artists, some authors, some employers, and distributors of copyrighted assets like film companies. It also causes concern among AI systems and platform providers because they don't exactly know what their level of liability will be. So they don't know how to plan perfectly either. No. Now, there's also sort of a larger concern, which is, will so-called synthetic images and text and sounds be so pervasive that they will, first of all, displace human attention span? Just be, everything is a AI-generated cat video. So, to paraphrase, well, I'll skip that part. And there's also the concern that this may have an effect on displacing current and future employment for artists and authors in a number of industries. It may result in fewer jobs in the entertainment production business Probably, according to some surveys, the most likely impact would be on entry-level workers, which is especially concerning because how do you move up in mid-career if you didn't come in at the entry level earlier in your career and get experience? Okay? It's also a problem for independent artists, which is, perhaps more than even employees who at least get a paycheck. Independent artists really live off their commissions and grants. And what they're often selling, either for primary rights or ancillary rights, is their copyright, their intangible asset in what they create. So that's why there are some worries. And I have to give an acknowledgement for this list of fear, uncertainty, and doubt, because this is paraphrased from the Sense of Congress resolution in Section 2 of legislation that was introduced in July. And I think Kurt was referring to it this morning, the Copied Act, which was introduced by Senator Maria Cantwell and was supported by Senator Marsha Blackburn, among others. And that would provide some means for sort of respecting copyright provenance information. And we'll talk more about that later, but I wanted to give credit where credit is due, that this is actually, these concerns are at least real enough for legislators to propose as being endorsed by a vote in Congress. All right. And this is the study I was referring to that the Animation Guild and others commissioned, which expressed concern about the impact, especially on entry-level employees. It's available on the internet. Go to the Animation Guild, which is tag.org, or I'm sorry, animation.org. All right, so let's go along and start talking about what are the forum in which the conversation about AI and artists and author rights are taking place. Okay. First of all, let's look at the US Copyright Office. Okay. This is the photo, it's an image of an illustration that was created by Stephen Thaler. In his words, wholly through artificial intelligence, a generative AI program that he developed. Okay, at least according to his application, his process was markedly different than what Amelia was telling us about in her work this morning. Dr. Thaler says that he put several prompts in, and the AI application produced this image, which he then fine-tuned a bit. Okay, and he applied to register copyright in the work, first of all, in the name of the machine. Davis is the name of his model and application. The Copyright Office declined to register copyright in this image on grounds that there is no human authorship in it, that there isn't sufficient evidence that it was created by a human being. Okay? That refusal by the Copyright Office first led to an appeal by Dr. Thaler to the Federal District Court in Washington, D.C., where the judge actually endorsed the view of the Copyright Office, finding that there had been a longstanding practice of assuming that human authorship is a requirement in order for a work to be protected by copyright. That decision of the district court judge is now under appeal to the DC Circuit Court of Appeals. It's been fully briefed, and there are arguments scheduled for later this fall. So we should have a decision, at least from one federal court of appeals, by, assuming the rapid pace at which federal courts work, June of 2025. And that's when the clerks who come on for a year finish their job and go on to other jobs. So that's probably the outside limit of when we'll get a decision from the Court of Appeals. Okay. And this case raises, the issue of where the line is drawn with respect to, is human authorship a requirement, or is it not a requirement for copyright? There's obvious commercial applications. If the owner of a machine, is able to generate content without much artistic direction at all, then and have an asset in it that can be licensed, for uses as quotidian but profitable as T-shirts and greeting cards and so forth, you can imagine that there's a whole lot less demand for graphic artists. Right? On the other hand, as we saw this morning with Amelia's work, there is a place for works that have been created under the direction of human beings with assistance from artificial intelligence and applications in that field. Perhaps analogous, but at a level beyond what we saw 30 years ago with the first computer-generated art, in which artists were writing code, for their designs. So we'll have to see. I for one think that we will probably get to an answer about this sooner or later. There's going to be some uncertainty for a while, but the Copyright Office in its decisions has signaled an openness to be convinced, they have sort of conceded that there is a place for AI models to be used as tools in the creation of works by artists and for those works to be protected by copyright. So I think we're going to be seeing, where there are some initial attempts to draw that line, and, not soon enough for any of us, but we will eventually see some line drawing that can be anticipated. So that's the Thaler case. All right. And this is the position of the Copyright Office when they made their decisions. When an AI technology receives solely a prompt from a human and produces complex written, visual, or musical works in response, the traditional elements of authorship are determined and executed by the technology, not the human being. Okay. And under those circumstances, the Copyright Office's view is that users do not exercise ultimate creative control over how those systems interpret the prompts and generate the material. So there are questions that, often are a bit outside of the realm of the law, of intentionality and indeterminacy, that at least the Copyright Office imagines or assumes did not exist with traditional human-created work, that there was enough determinacy between the thought and intention of the artist working on the canvas or writing code for a computer-generated work, to reassure the office that there was that the artist knew somewhat what was going to happen. What would be produced using the brush, using the pencil, using the computer program. Okay, and as we get closer into learning more about AI, we may get some more information and some more resolution of this issue. So, or we may even consider that reach the determination that it doesn't matter much at all. So, that's the status of that question. So stay tuned for the appeals court decision. That brings us to the pending lawsuits in U.S. federal court. Okay? And these involve a different issue. They don't really involve ownership or copyright being granted in a work. They really concern use of a copyrighted work without express permission, and perhaps even without implied permission, by artists and authors in order for AI model developers to assemble databases to train their models. Right? And there's a number of these suits. There's a complete list on the Variety newspaper website, which is updated frequently. But they range from a number of lawsuits against Stability AI, a couple of class actions brought by visual artists like Sarah Silverman. There we are. And also by authors like Ta-Nehisi Coates and others. So the issue here is that AI models like Stable Diffusion, are trained by being exposed to large amounts of data. In this case, it would be image data. And the data on which they are trained have been assembled by other parties, like, for example, the nonprofit that produced the Leon image databases, or as Kurt was explaining, the spreadsheet of URLs in the Leon database. And then in order to train the AI model, there needs to be some sort of reference or review by the computer scientists of the images at the other end of those links. Okay? So the contention of the artists are that, well, first of all, we have a copyright, and that copyright gives us certain exclusive rights. So our paintings, our illustrations, our books are protected by copyright, and therefore we have an exclusive right, subject to a couple of exceptions, to authorize or refuse to authorize other parties from making copies of the work, or from making modifications to the work in order to make a derivative work, okay? Or to transfer it to another format or medium. Those are all rights that are within copyright. Now, what the artists and authors have alleged is that that's what happens when a data set is assembled, at least at that level, where there's data being copied by somebody along the line, and then being exposed to the incipient AI model. Okay? The technology developers take a couple of positions. One is that, well, that's not really what happens inside the black box. And we'd be happy to tell you what happens in there, but it's a trade secret. So all of the filings in the lawsuit are subject to a confidentiality order. And so access is restricted to the judge and the judge's clerks and the parties involved. So we don't know much at this point either. But there has been enough information provided that that courts at least think that there is a genuine issue here, and that the artists and authors have stated a claim. They haven't proven a claim yet, but they have stated a claim that will survive a motion to dismiss. Okay? And that's where the status is for most of these cases being brought against AI model and system developers, that the court has dismissed a number of claims that the artists and authors have brought. Items like, you're not respecting our copyright management information, that you are unjustly enriching yourself by using our works in order for this productive purpose, right? The technology providers say, yes, but even if so, those claims are preempted by the US Copyright Act. There's a little bit of a supremacy clause in the Federal Copyright Act that says that any state or common law that deals with what is or could be handled under the copyright law are preempted, and only the US copyright law can apply. So that's been the basis for many of these other claims to be dismissed. So we have the enduring claim is there direct infringement in the course of assembling data sets and training AI models? And this will probably, the next stage of these proceedings will probably be a motion for summary judgment, where after a period of discovery and each side shows some of their cards, the court has to decide, has one party shown enough proof of the pertinent issues that it really is unnecessary to go to trial? That we've seen enough and we don't have to have a trial about this. So that'll be the next stage in this. And I think Kurt is right. I think we're probably a year to a year and a half from the motions for summary judgment, because we're going to see some more discovery taking place. If we go to trial, we're probably looking at a good 2 to 2.5 years before we have a resolution. Now that's for these cases, okay? And I'll also remark, these cases are taking place in a couple of clusters. Okay? So many of the artist and author suits have been brought in the Northern District of California, where the court sits in San Francisco. Other cases, like the New York Times versus Microsoft, or Getty Images versus Stability AI, have been brought in the federal courts in Manhattan and in Delaware, respectively. I would hazard a guess that it's important for the cases to have been brought in different districts, because the Northern District of California has, I wouldn't say a prejudice, but its clerks are so versed in technology and so comfortable with it that, and less versed in sort of artistic expression. I mean, Stanford has a center that's mostly devoted to technology. Now, that doesn't mean there's like prejudice, right? But there may be a comfort and predisposition. And the clerks are really important in deciding, helping the judge decide complex issues. Now, clerks over in Manhattan and Delaware probably aren't going to have that same, background information. Doesn't mean they're not able to apply the law in an accurate way, but it just may be a different perspective. So we may get conflicting decisions eventually, and unless there's some other resolution before then, it may go to the Supreme Court, right? All right, so that's that. Oh, I will say this. We may get an indication of which way these cases are going sooner rather than later, courtesy of cases being brought in other fields. So, for example, there is the Doe versus GitHub case in the Northern District of California. This is a case in which an anonymous class of computer programmers brought an action against GitHub on grounds that the computer code they had written had been copied and used to train GitHub's software writing code AI model. Okay? Now, that case is proceeding. It started before these traditional content cases, and it is scheduled for trial. So we may get a decision, at least based on the issue of whether there is an unauthorized reproduction being made in training a data set or assembling a training data set. Right? Also, there's a case, where is this one? Actually, it's in the DC Circuit, which is Thomson Reuters Enterprise GmbH versus Ross International. Okay? This is a case that concerns the driest material you can ever imagine. And that is head notes summarizing portions of legal opinions. Okay? So now, legal opinions, at least at the federal level, are works of the US government, and there's no copyright in them. It's a good thing. It's a pro-transparency matter. Now, some publishers work to add value by preparing abstracts of what that 30-page case says, what's the bottom line. They also prepare what are called head notes, which are little summaries of sort of preliminary or intermediary decisions the judge made. Okay, so what's at stake in the Ross International case is that West Publishing, owned by Thomson Reuters, had been preparing an AI system of its own, an internal sort of clean system where they would use their abstracts to train an AI model for legal summaries. Okay. Somehow, one of their contractors in that process provided a copy of the West database, including the copyrightable head notes and abstracts, to Ross International, which then went ahead and is training and prepared a legal AI model. So that case has gone, it started earlier, and it will probably reach a decision sooner. And if it does, that's going to give us a decision in whether assembling a training database involves copying copyrighted works, namely those abstracts. So although we may not get the answer in these artist and author cases, we may get answers, or at least some forecasting from these earlier cases that are set for trial. All right. Okay, and of course, this highlights something, the core issue is, as the Copyright Office observed when it issued its notice asking for comments on AI and copyright, that the Copyright Office is aware that there's disagreement about whether or when the use of copyrighted works to develop data sets for training is infringing. Okay? So there's this whole question of, is there a reproduction made? Because the Copyright Act doesn't prohibit use of a copyrighted work. It's not like the Patent Act. The Patent Act, oh my God, if you get a patent, you can prohibit somebody else from using that invention. That's why, that's why the original Hollywood studio heads went to California to get out of the reach of the Pinkerton Detective Agency and Thomas Edison, who had the patents for motion picture cameras. And so every camera not only had to be built to conform to the patent to be serviceable, but they also needed to pay a royalty to Thomas Edison. That's business as usual in the patent field. But the original studio heads packed up and got out of range of the Pinkertons so they could use cameras that had not been assembled under license. So that's just to illustrate how powerful the Patent Act is. Copyrights, in contrast, do not enable the copyright owner to authorize use of the work. The libraries would call this the right to read. What it does is it gives the copyright owner a set of 6 exclusive rights. Use is not one of them. It's making copies, distributing those copies, publicly displaying the copies, publicly performing works like videos or musical compositions in public, and then making derivative works in another format or sequels or reimaginings. But there's not a general prohibition on use. So that's what's going to be determined. Now, the Copyright Office was asked to examine this question. They have not yet. They released part 1 of their study in July, and that deals with an issue close to the heart of performers, which is the Copyright Office is endorsing some sort of federal legislation that would give individuals a federal right to prohibit people from making digital replicas of them and then using them. Currently, there's only state laws in that regard, and they really don't encompass digital replicas as such. So the Copyright Office took its position in this. Of interest to artists and authors, the Copyright Office also said it disfavored federal legislation that would protect artistic style apart from the expression, if you will, in a copyrighted work. So style, from the copyright point of view, Copyright Office's point of view, should not be subject to an exclusive right. All right. And this opinion, this headline from the Hollywood Reporter has a hopeful note, but it doesn't really stir me on the copyright side. It stirs me on the trademark and unfair competition side. And this headline relates to a case against Midjourney by, this is another class action by visual artists. Okay. This case does allege direct copyright infringement in putting together data sets, but it also alleges that there has been infringement of trademarks and unfair competition. And this is a backdoor to style, because Midjourney and one of its licensees at one point were making available an AI platform in which users could select from a list of, I think it was 140 artists identified by name, say, exactly, you're anticipating what I'm about to say, which is, you put that artist's name in with another prompt and you get a illustration in the style of that artist. Okay. The plaintiffs alleged that that was false endorsement and sponsorship. Not that they have a right in their style, but that by putting their names up and suggesting that people use them as prompts, that suggest to users that the artist somehow endorsed this or involved, and none of them were. So that's sort of an outline set of facts, but I think that's going to be a very interesting issue to consider. All right. Let's say all these lawsuits on direct copyright infringement fail, okay? The artists don't prevail. The AI platforms prevail in their claims either that there was no copy made, or even if there's a copy made, it's excused by fair use. That training an AI model is a productive social purpose and a transformation of the work created by the individual artists. Okay? It's not a crazy claim. There are cases that support this, like the Authors Guild versus Google case, or the Hathitrust case, in which Google mass copied copyrighted literary works and then provided to the public a search system in which people could search for keywords and concepts in those works. And they would get an output, which was like a window on your email. It would be like 2 or 3 lines from the book. And that's all you could see. So you would see that and you would see the citation. Federal courts ruled that that particular use, even though there had been copying of entire books without permission and without payment, was excused by fair use because there was, in the court's opinion, little effect on the commercial exploitation of the books. That snippet would not displace or function as a substitute for the copyrighted work. And that there was a transformation, that by changing the format and making it searchable, that was enough of a contribution of new capability to justify fair use. Okay? So it's not an outlandish claim, that the AI platforms would assert a fair use defense. And we'll have to see how that's considered. Okay. Now, that's if they fail. What if the class actions by the artists and the authors succeed? Okay. What's the result? Well, first of all, because they're class actions, guess what? The remedies are not limited just to Sarah Silverman and her colleagues who brought the lawsuit. Those remedies, if there are any against AI platforms, will be available to everyone who fits within the class identified in the lawsuit. The class action lawsuits identify the eligible class or to enjoy remedies as any artist or author whose work has been copied in training the data set or preparation of the AI model. So if there is success, there'll probably be an order to disclose everything that was copied by the spiders to assemble the data set, and then you'll get a letter in the mail like I do when there's like a recall for my car, or AT&T and my mobile phone plan has been found to be promising more than it delivers, which is, you may be eligible to be in the class. Contact us and we'll tell you if you are. And if so, you get a share. So that's the first thing. Because they're class actions, a lot of artists and authors may be eligible to participate. Not in the trial, but in the rewards. Okay. Second, going forward, a favorable judgment on copyright infringement would provide copyright owners and artists and authors with leverage to negotiate a forward-looking industry-wide agreement. Probably separate agreements for different industry segments, but nonetheless comprehensive agreements in some way as to whether there is some payment required, some protocol for permission, and then some method of collecting and distributing the monies that are collected for those uses. That's what success would mean. All right, so that brings us to licensing. Let's say that favorable result occurs. Okay? Would the AI platforms be able to send you a letter or an email and say, could you please give us permission to use your work in our data set? Probably not. Just like 25 years ago, when the DMCA was being negotiated, the AI providers like the telephone companies and America Online will say, it's just too much trouble. It's just too much effort to get small amounts of permission from a huge number of copyright owners. So that argues in favor of a more comprehensive solution. And there's several ways this could happen. Okay. One, we're seeing already that agents for copyright owners are negotiating licenses with the AI platforms. So, for example, Getty Images has been out in front providing licenses to AI developers to use the images within their catalog as training material. Time Magazine. Does anyone remember when people read Time Magazine? I do, but it was a long time ago. Anyway, they licensed their whole back catalog, like all the stuff from a century ago that is meaningful. They licensed all of that to the AI platforms. Okay, and a lot of other, sort of agents or aggregators or representatives of artists and authors have been doing so as well. Now, here's a hint. This is a great thing. The idea that, oh, yes, my agent is being asked for permission. There's two hitches for you, the individual author and artist, to think about. One, am I going to see any of that, and how much will it be? Two, did I give my agent the right to license my work for AI training when I signed the agency contract? I don't know. It's unlikely it specifically said that. But if, for example, the agency agreement was limited, you only gave them a right to license publishing rights, then it doesn't. And your agent may be working ultra vires. Your agent may be a stock photo company. It may be Getty Images. It may be the Artist Rights Society. So, dig out those agreements and see, what you gave them authority to do. That's one issue. That individual licenses, let's say you are an independent artist, you're not represented by an agency or an aggregator. What can you do then? Well, I think your professional societies, like the Graphic Arts Guild and and some of the other guilds the Authors Guild, should be promulgating model contracts. If you are involved in individually licensing your works, it's like, here's the book I just wrote. You want to publish it? We're doing a deal. Keep track of what you are granting the publisher permission to do. You may or may not want to make licensing for AI training data sets to be a deal point. It's kind of hard to know what the price is for that at this point, but that'll become more clear over time. But take a look at that to be prepared. Okay. And then finally, a licensing regime can involve collective licenses. So a collective license is when there is an organization that represents a substantial number of artists and authors in a particular field, and thereby gains either the leverage or, in Europe, the legal authority to negotiate and collect royalties and distribute them to all the artists in the field. Okay. So a good example in the field of songwriting in the United States are the two collecting societies, ASCAP and BMI. They're voluntary. You sign up for them if you're a songwriter, and then you give them the authority to grant licenses to TV stations, to social media sites, to museums, to restaurants, to bars, and to perform your song either live or on the radio. And using their own black box, but there's many songwriters relatively happy with this. The songwriter, they distribute the proceeds of all of those licenses on a, sort of estimated basis based on frequency of play. One of the problems we have today is just that so much in the music field, and this really is so many airplays and internet plays are being absorbed by a small number of superstar artists. you know, and there's not as much room for airplay for average songwriters and average recording artists. But there's still the system in place, and something's better than nothing. So we may see a growth of collective blanket licenses where that society says, look, you, OpenAI, we will give you permission to use anything that has been created by all these people, like every one of our members, millions of them, in return for a royalty that's going to be computed on several parameters. Okay? And you know what? You don't need to come back and ask us each time. You know, it's just like you get it for the year and it renews and you pay the same thing. That's an example of collective licensing. There are some groups that have done this already outside the field of AI. For example, the Copyright Clearance Center has done it for reprographic rights, photocopy, and remember that, for years. And now printing from scholarly journals. And they've just instituted a blanket license for AI uses, and they're recruiting aggregators, agencies, individual artists, and authors to become members of that program so that they can issue blanket licenses to the platforms. So stay tuned for that. And, key things to remember is, what's your track record for distributing to smaller artists? What can I expect to get? Is it worth the trouble? All right, and here's a couple of examples. We have two groups, Copyright Clearance Center, and then on a smaller scale, Artist Rights Society, which they administer and act as an agent for things like the Warhol estate. So they're in a position to grant either rights for individual works or, less commonly, an assortment of works for a particular project. All right. Now, how am I doing on time? 5? Okay, let's wrap up with collective bargaining agreements. Okay. Some artists and authors, don't retain their copyrights because they are employees and they create works in the scope of their employment. Others may be individual or independent contractors, but they are contributing to audio-visual works like motion pictures and videos. Those classes of artists, generally do not retain their copyrights. They're owned by their employer. Okay, but at least in several sectors of the entertainment field, they have collective bargaining agreements. They are a labor union, right? And we have seen in the last year several groups that have successfully negotiated provisions related to AI. So we all know the writer's strike from last year. Writers Guild, West and East, negotiated an agreement with the it's the Association of Motion Picture and Television Producers. And the big 7 studios, the production companies, and a long list of independent companies. And so they've had master bargaining agreements for a long time. They negotiated AI provisions. Okay, IATSE, the labor union for scenic designers, animators, for costume designers, for stage directors. They recently negotiated an umbrella agreement with the same group for television and theatrical productions. Okay? And they got some AI provisions as well. So let's see, we have a side-by-side here. They differ a bit. The television writers did a little bit better. One, the company cannot require a writer in the writer's room to use ChatGPT. Okay? In contrast, if you're a member of IATSE and you're doing other functions, the producer may require the employee to use an AI system or output. So like if you're a scenic designer, the producer may require you to use AI. But for the same project, the writer can't be required to use it. Okay. Now, if a writer wants to use generative AI to produce work, the company needs to consent. and the company reserves a right to refuse to grant consent. So, you know, the company has a veto right over the use of AI by the writer. If the company is the one handing the writer some AI output, then, okay, two things follow from that. First, the company or producer must disclose to the writer, yeah, this was made by ChatGPT. See what you can do with it. Okay. Second, to discourage labor substitution, the fact that that material handed by the producer to the writer has no impact on the compensation paid to the writer. You know, whatever ChatGPT produced is not treated as literary material for purposes of writer compensation. And the fact that the rewriting the writer does is rewriting that, you know, the writer didn't write the story and then rewrite the screenplay. That doesn't diminish the writer's compensation. So these are some powerful disincentives for producers to try to substitute the use of AI. IATSE doesn't have quite, you know, as strong of protections against labor displacement. We're going to see a bit of a showdown later this month. The Animation Guild, which is a local for IATSE, will have a different contract. They're negotiating their 3-year contract now, and I expect that they are asking for assurances that are more like the Writers Guild than the scenic designers. Okay. We've got legislation. We can talk about that during questions and answers if you like, because I'm out of time. Yeah.
We got time for like one question.
Yeah, let's do that.
One question. We have one.
And I'll send my slides with the summary of the legislation, okay?
We have one brilliant question.
I have answered all of your questions,
Oh, great.
or I have put you all to sleep.
Here we go. Your light is on.
My question is, you talked earlier about data sets and the legal implications of data sets. If there are nefarious images that were collected in the data set, and then someone generates an image unknowingly using that those nefarious images, who's guilty currently?
Use the mic.
I would expect.
Yeah.
It's uncertain. I think that is why, for example, in the IATSE agreement, which again is just limited to some sectors of the entertainment industry, doesn't include in-house graphic designers for consumer products or anything like that. The company or producer must indemnify the individual employee against any claims related to the output if the producer requires the employee to use AI in the project or has consented to it. So you're still going to get sued, but the company's obligated to pay for your defense, you know, and probably you're not the only one being sued. The company will be there with you, so your interests will be aligned, you know, in that. I know it's not completely reassuring, but it's something. Okay, folks, thanks very much. It's a lot
Thank you, Mark.